welcome to today's episode. We're diving into a case that's been making waves far beyond Texas, the Jordan Lee Williams case. It sparked a heated debate about bail reform, judicial discretion, and public safety, not just in Texas but nationally, including right here in North Carolina. Chloe, this case really shines a light on a core tension in bail reform, doesn't it?
It does, Liam. At its core, the Williams case forces us to ask, how do courts reduce unnecessary pretrial detention without releasing people who pose real dangers? Even though this happened in Houston, the bail systems in Texas and North Carolina share enough similarities that this case hits close to home.
Right. And while Texas and North Carolina have different legal frameworks, the practical side of bail decisions is surprisingly similar. For instance, in both states, magistrates, not judges, usually set initial bonds. These magistrates often have to decide quickly, relying on limited info, like rapid risk assessments, incomplete criminal records, and little input from prosecutors.
Exactly. And both states allow unsecured bonds or personal recognizance bonds. That's basically a written promise to appear in court, even for felony defendants, unless specific laws say otherwise. That's key, because it means serious charges don't always require money up front, which is a big part of bail reform's goal to cut unnecessary detention.
But that speed and efficiency come with risks. Magistrates work under tight time pressure, which can lead to high-risk defendants being released before a full judicial review. The Williams case is a warning here. His prior violent convictions didn't stop his release because the system's reform-driven presumptions favored letting him go.
That brings us to three major triggers this case has set off for bail reform in North Carolina. First, there's renewed scrutiny of magistrate authority. Lawmakers and advocates are questioning whether magistrates should have the power to release felony defendants without secured bonds, especially when violent histories are involved.
And the proposed reforms are pretty specific. They include mandatory judicial review within 24 hours for defendants with violent felony records, limits on magistrates, discretion for repeat violent offenders, and clear rules that unsecured bonds should be prohibited, not just discouraged, in certain cases.
What's striking is that risk assessment tools alone aren't enough. When magistrates' discretion can override clear danger signs, those tools lose their value. It's a real tension between reform goals and public safety. And magistrates are right in the middle, often making decisions with limited info and under time pressure.
The second trigger is pressure to redefine what low risk really means. Bail reform relies heavily on risk models designed to reduce racial and economic disparities by identifying low-risk defendants. But the Williams case exposes a flaw. Someone can be low risk for skipping court, but still pose a high public safety risk.
That's a crucial distinction. North Carolina's system doesn't always separate these risks well. Think of it like a medical triage that only checks if a patient will show up for follow-up but ignores if they have a contagious disease. You're missing a critical risk.
Exactly. So legislative debates will likely focus on separating public safety risk from court appearance risk, requiring courts to weigh violent history over reform benchmarks, and considering automatic disqualification from unsecured release for certain offenses.
The third trigger is accountability for judicial actors. The Williams case highlights a transparency gap. Magistrates' bond decisions are rarely public or explained in writing, and there are few ways to hold them accountable.
In North Carolina, this has led to calls for public disclosure of bond decisions in serious felony cases, written explanations for unsecured releases, and legislative oversight of bond-setting trends by county. The public's question shifts from, why was he free, to who made the decision and why.
That shift is vital for restoring trust. Without transparency and accountability, it's hard for the public to accept these decisions, especially when they lead to tragic outcomes.
Now, putting this case in the national context, it comes at a politically charged moment for bail reform. States like New York, Illinois, and California have faced backlash after crimes by defendants released pretrial.
And federal courts are increasingly emphasizing public safety exceptions to pretrial release. Prosecutors. Groups warn that ideological bail reform has outpaced necessary safeguards. The Williams case adds fuel to arguments that reform has expanded too broadly and too fast.
There's also concern that violent repeat offenders are treated as statistical outliers rather than real threats. We might be seeing the pendulum swing back toward more targeted detention and secured bonds.
That's a big political consequence. Legislators will likely propose narrowing eligibility for unsecured bonds, mandating higher scrutiny for repeat violent offenders, and shifting liability concerns back onto the state rather than victims.
Prosecutors will probably object more aggressively at initial bond hearings, push for immediate bond reviews, and publicly oppose blanket reform measures. Meanwhile, reform advocates are on the defensive, needing to clarify that bail reform was never meant to protect violent offenders, accept tighter public safety carve-outs, and work to rebuild trust.
So what does this all tell us? The Williams case isn't an argument against bail reform itself. It's a critique of how reform is applied without enough guardrails. Equity without accountability invites tragedy. Speed without scrutiny invites failure. Reform without restraint invites reversal.
Public safety must be the non-negotiable foundation of all bail reform efforts. North Carolina is watching closely because the same legal mechanisms exist here. What happens nationally will influence how courts, lawmakers, and voters decide whether to recalibrate or roll back reform.
It's a complex issue with no easy answers, but the Williams case forces a reckoning. Transparency, accountability, and balancing reform goals with public safety are essential if bail reform is to survive politically and legally.
Well said. That wraps up our discussion today. Thanks for joining us as we unpacked this critical case and its wider implications. We hope this gives you a clearer sense of why the Jordan Lee Williams case matters beyond Texas and what it means for bail reform's future.
Thanks, everyone. Until next time.